statement of fact on the table, to invite Mr. Lafleur back so that we can ask him additional questions about the content of that document, because frankly, a bunch of us are playing with one hand behind our back because for whatever reason, certain witnesses felt that giving those documents to some members of the committee and not others was going to be to their advantage. And, you know, we're in a situation where obviously these allegations are extremely serious. If the allegations that have been made in the Bottler report turn out to indeed be true, this indicates that there is serious wrongdoing amongst civil servants working on the ArriveCan procurement. And that's something all Canadians should be concerned about. So, Mr. Chair, if you'll grant it, I will make a motion that the committee be provided with a preliminary statement of fact immediately.
Maybe just a quick point of order.
You will burn out your time to discuss your motion to begin with. The second, I would ask you that we wait. Again, I will discuss it, how we will proceed with it in camera, or we can do it publicly if you wish. It's up to you. But publicly. Sure, we'll do it.
Sorry, just a point of order. I don't know if the motion would be in order because I proposed exactly the same motion and the committee adopted that motion. I think early last week, and it had a 3-week deadline. So I gather we're going to have a discussion about how to dispose of these documents.
It's a duplicate of actually Mr. Genoves's motion from 3 weeks ago.
Can I respond, Mr. Chair?
No.
I think
it is.
The committee has ordered the documents.
Let me interrupt. I have the floor here. Mr. Genoves, I have the floor. Yeah. Mr. Genoves is right. It was basically you're asking for a duplication of a motion that's already been received. We'll discuss it right now, actually, then, and we may lose the time for your motion, but we're going to discuss it right now, committee. The request came in from Mr. Genoves for these documents. We agreed. The committee agreed to pass a motion to have the documents provided. CBSA wrote to me saying we will provide one copy only, and it'll be under lockup. No one will see it. One copy and wasn't translated. We wrote back saying, no, that's not the motion. You will provide it. She wanted it held in private for sensitivity. We wrote back saying, please provide it. So I will take a look. I will read through it to see how sensitive it is, see if it actually is sensitive stuff. I've read through most of it with notes that I was going to discuss in camera, but we'll do it publicly. I was going to suggest that we distribute it only to the members itself, not to the wider 48 people generally on our email list that it is provided. I spoke to the clerk today before the meeting on how we do that. We just need a motion. My suggestion was going to be to propose we share it translated, but only to the members itself, not to our staff, not to the usual 47 people on the list. That was going to be my proposal on Wednesday. It seems to be moved up. If you wish to discuss it now, that would be my suggestion, that we share it only with the members. Mr. Sousa?
So, Mr. Chair, the issue that we're having here is obviously Mr. Brock, who's not a regular on this committee, has had access to this statement of fact. You're aware that he had it, and you have it, and yet you didn't.
Let me interrupt. I was aware he had it when he spoke about it, but I have to question whether this is the first. I'm going to say it to all of you, and I'm very kind of stunned. It's almost like the first committee, all of you. The amount of time all of us receive reports or emails or ATIPs to us that don't go to everyone.
Mr. Chair, my question
and
is...
And yet, also now someone has one and it has to be shared?
No. Listen, I just want to understand, Mr. Chair. I apologize. I'm not as astute when it comes to these procedures, but it seems to me that if you're aware that Mr. Brock has a statement of fact, you have it and the clerk has it, and you decided not to then share with the rest of us, knowing that...
that's not the case, Mr. Sousa, and this will be the third time I've said it to you.
So when did you know that he had it?
You asked that earlier, and about 15 minutes ago, when he stated at the opening that he received some information from the witnesses. The witnesses, I'm aware, and their lawyer, I am aware, have a copy of it. Mr. Lafleur and how many people, CBSA or CBSA, have it, I am not sure. But even if it was shared by the witnesses, or Mr. McDonald or Mr. Utano, that's their right. And that's their right to share it with anyone they want. But that does not mean that you have the right to see it or that anyone else.
No, but we're asking, Mr. Chair, I'm just trying to understand. I'm asking for the committee's right to have information shared when it's already in the hands of others, and knowing that it's in the hand of others, it could have been appropriate for us to suspend and then share that document. I guess that's all my point, so that we can all have seen
I
it.
will repeat, as I said earlier, before the meeting started, discussed this with the clerk. My opinion was to share it only with the members itself. I asked for procedure on how to do that. Before the meeting started, the clerk advised, do it as a motion. My intent was to do it in camera Wednesday, but now it's been pushed ahead. But if you wish, we can do a motion right now to share it just with the MPs, which is my thought, or with the broader mailing list, which is, as we generally share other issues, or we share with the MPs with the understanding it remains confidential, which is how we do on documents. But someone sharing something that is theirs to share with, they decided to share with you, that's their business, and that is your business. That does not mean has to be shared with everyone else until the committee decides. We were going to decide it Wednesday, as I discussed with the clerk at the beginning, and you can confirm that with her if you wish, but it seems to be pushed to right now.
It seems appropriate, and I'm just concerned that somehow it's been held off, knowing that Mr. Brock had it.
I will repeat, Mr. Sousa, if you wish to check with the clerk and reconfirm my discussion with her at the beginning, we will do so, Mr. Sousa. But I'm getting a bit tired of your insinuations that perhaps some people are receiving the information inappropriately from the clerk or from myself. Mr. Brock.
We are wasting such valuable time with this important witness. Given the fact that we have more committee business to undertake, I am asking that we reserve our right to recall this witness. I think there are a lot of more questions that all members, and if the motion is passed in terms of release of documents, are going to have for this individual. Insofar as preparation of this particular meeting, every member exercises their own unique due diligence. So what I do in terms of preparation should not be the standard by which any other member should equate that to. I take this stuff very seriously, as I know my colleagues do. And there's an important point to make here. There is no proprietary interest in any witness. There is nothing preventing from any member of the Liberal bench from actually reaching out to Cameron McDonald on the telephone call or Mr. Utano and asking pointed questions, which is precisely what I did. I spent some time with both individuals gathering information. That information, I'm not under any legal obligation to share that with opposing members.
I agree. Colleagues, are we ready to make a decision and move on, or would you like to discuss it further Wednesday, or